Hello, and thank you again for joining us on another episode of Tech Policy Grind, the Internet Law and Policy Foundry's new podcast. Each episode will hammer out the latest in tech law and policy by talking to friends and fellows of the Foundry. The Foundry is a collection of early to mid-career professionals paving the way at the intersections of law and technology. My co-host today is Emery Rohn, a recent law school grad waiting to be sworn into the California bar, and a fellow at the Internet Law and Policy Foundry and Privacy Rights Clearinghouse based in San Diego. I'm Pinal Shah, an attorney working in GovTech based in the Bay Area. Our other co-host, Joe Jerome of DC, is traveling this week and couldn't be with us today.
This episode, we're going to dive into the very timely topic of net neutrality, or more specifically, the Federal Communications Commission's recent announcement that it intends to roll back the net neutrality protections under the 2015 Open Internet Order. So net neutrality is not a new concept. Tim Wu coined the phrase back in 2003, but it's a topic that has been especially contentious in recent years. So while there's no firm definition of what net neutrality is, at a high level, net neutrality is the principle that internet service providers should be treating all data equally. So everyone seems to agree on some notion of net neutrality in principle, but we've been arguing since at least 2010 on whether or not the FCC should make formal rules enshrining the concept. Understandably, strong feelings have emerged on both sides of the debate, and today we're going to drill down into some of the tougher sides of the issue.
Yeah, so today we're joined by Tom Struble and Randy Abreu to get us up to speed. On the side of repealing the Open Internet Order, we've got Tom. He is a technology policy manager at R Street Institute. Prior to joining R Street Institute, Tom worked at Tech Freedom, the Competitive Carriers Association, and the mobility division of the FCC's Wireless Telecommunications Bureau. Opposing the rollback is Randy Abreu, an attorney, published author, tech-aficionado, and recent candidate for New York City Council from the Bronx. Randy is an alum of the Google Policy Fellowship, Congressional Hispanic Caucus Institute Law Fellowship, and the Obama administration, my brethren. Thank you for joining us.
Thanks for having us on.
Thank you.
So we often kick off the podcast by asking what folks are grinding for in tech policy, but we'll get to that a little later. We thought we'd flip the script this week and ask where you're both coming from on this net neutrality debate. Tom, your organization, R Street Institute, just a couple of days ago hosted Chairman Pai to talk net neutrality. Why is net neutrality so important, and why are folks so up in arms about it? Tom, why don't you go first, and Randy, if you can respond.
Sure. So, yeah, as you mentioned, Pinal, R Street Institute, along with Lincoln Network, co-hosted an event this week with Chairman Pai from the FCC, Acting Chairman Olhausen from the FTC, then also Commissioners Carr and O'Reilly from the FCC. During the event, they all spoke. The FCC commissioners discussed the forthcoming Restoring Internet Freedom Order, the draft of which was released last week. Chairman Olhausen, by contrast, spoke about the FTC and the role that they can play in regulating broadband once their jurisdiction over broadband service is restored. We can get into later the whole Title I, Title II classification debate and the jurisdictional issues that come along with that. But in broad strokes, it was about the future of broadband regulation as it shifts from entirely at the FCC to a collaborative effort between the FCC and the FTC, with the FCC still requiring mandatory transparent disclosures from broadband providers, but the FTC taking primary responsibility to enforce those promises and to otherwise police any unfair methods of competition or unfair or deceptive acts or practices.
Randy, does that sound how you would describe the issue, or do you have anything to add to that?
Technically, yes, that is what's going on in the debate, but I don't think is actually being talked about enough is the reason net neutrality laws were passed and was succeeded through the courts just a couple of years ago was specifically because government wanted to ensure that private companies wouldn't take advantage of an internet market. So it wasn't really where the government we're telling you what to do. It's more of since we are the government, we are letting everyone know what not to do in terms of the internet market. So I think about 2 years ago, we got it right when we finally got net neutrality passed, and we see what's going on now. It's a rollback of these protections, and that's where I see the debate standing now. Where I come from, it's the internet to us in a lot of communities. It's the great equalizer of our time, the openness, the freedom, the promise of net neutrality. If we can't protect that, then we're losing a lot of potential moving forward. I think that's an issue that's where I see it, and that's where I see the importance of all of this.
So
Sure. Oh, sorry. I guess I forgot to respond to the second half of that question. But yeah, Randy reminded me because, I guess basically just gave a description about what's happening. But to the question about why net neutrality is really important, our street and myself in particular have been, consistent and strong supporters of net neutrality. You can read our comments. We filed, I think they were reasonably short, like 30 pages and 15 in reply. Filed comments with the FCC.
That's reasonably short in DC terms, I'd say. Yeah.
Right. Yeah. Fair, like Free Press, Tech Freedom, a couple others filed like 200 pages each, and I don't know who has time to read that. But in terms of net neutrality, we are still strong supporters in net neutrality or internet freedom. These aren't precise terms, but the general that
I think that we should maybe
be open and fair and competitive. And I think we're, in rolling back the FCC's 2015 rules, we're switching and transferring jurisdiction to the FTC. We're switching from a net neutrality regime based on ex ante rules to one based on ex post adjudication under standards, which is really inside baseball. I mean, I guess argument about rules versus standards. I don't know if we want to get into that, but
this is definitely an inside baseball podcast, so we will love to get into that. I think before we do, just for our listeners that may not be as up to speed on the open internet order itself, the broad strokes of what net neutrality as enshrined in the open internet order provides. Randy or Tom, do you want to give, I guess, a summary or point by point of what was provided in the open internet order back in 2015?
I can say briefly that the Open Internet Order of 2015, it provided what some would call these bright line rules of net neutrality that are intended to protect consumers. They were intended to protect consumers against anti-competitive practices. So what was established was what internet service providers cannot do in terms of data that travels over these pipes. So what we can't do if I'm an internet service provider, according to these net neutrality laws, I cannot slow down another company's data that's coming through the pipelines. I can't, which is called throttling. I can't ask another company like Netflix, for example, to pay me, Comcast, for example, to pay Comcast some money just to speed you through the system because, hey, a lot of people want to watch Netflix around 9 p.m. at night. So that's hurting our pipes here. That's making it harder for us to compete, is what Comcast will say. So the net neutrality laws of 2015, I think, established and formalized and codified the idea that, well, yeah, we want to preserve the openness of the internet, but we also want to make sure that no one will ever discriminate against lawful content that flows through the internet. And it just set procedures, policies, and a framework towards how we can always ensure that.
Sure. Yeah. I'll, I guess, offer some more details along those lines because, the 2015 order had 3 bright line rules: no blocking, no throttling, no pay prioritization. It also enhanced the transparency rule from the 2010 Open Internet Order. It also had a general conduct standard, say like no unreasonable discrimination or unfair practices that would be assessed on a case-by-case basis. So it had both bright line rules and a general conduct standard, which is significantly different from the 2010, the first Open Internet Order that Julius Janikowski put out during the first Obama administration, which I guess I personally like the 2010 order and those rules more than the 2015 rules because they were a lot simpler. The 2010 rules was just no blocking, no throttling, and no unreasonable discrimination. Which was, and plus transparency, which didn't get struck down. But just those 3 rules I thought were simpler and provided, the same level of protection to industry, edge companies, broadband providers, and consumers than the 2015 order, because while it had, bright line rules, each of the 3 rules had exceptions to them. Like you couldn't block except under these certain circumstances. You could block, unlawful content or bots or, cybersecurity attacks or things you can block. Also, throttling, you generally can't do that unless it's for network management purposes, in which cases, throttling is allowable. And prioritization offerings were also permissible. Yeah, that was a big deal with T-Mobile, Spain John, different 0 rating plans. But even the prioritization ban, there was a strict ban on paid prioritization with any affiliates, or if you're getting paid, if money's changing hands, prioritize one service over another. But the FCC in the 2015 order said explicitly you could offer those sorts of curated prioritized offerings, but you had to bundle them and sell them separately from broadband internet access service, the general purpose internet that you buy. So it's saying that you could, if you want to do anything new and innovative with priority, you have to label that separately. And even then, it was subject to the general conduct standard and could still be struck down if it were unfair to different, I guess, groups.
So can we talk a little bit about how the FCC takes jurisdiction over the internet in 2010 and in 2015? Is that what's being pushed back against now? Or what was the history for that process?
Sure. So I'll get into this because we talked a lot about this in our Streets comments earlier this year with the FCC, when we actually pushed them to go back to rules that looked a lot like the 2010 order, a transparency rule and a no unreasonable discrimination rule, which I think would encompass harmful blocking or throttling. The 2010 order was based on Title I, while broadband was still lightly classified under as an information service, along with Section 706 from the Telecommunications Act of 1996, which isn't actually in the Communications Act. It's like a free-floating provision, but it also arguably gives the FCC some authority. Several courts have said that. Although other courts have said it doesn't give them very much, so it's still uncertain how much authority is in 706. But that was the big fight in 2010. Verizon challenged that order, at least from what I understand. It's because they didn't trust Section 706 as a grant of authority and thought that if it could be used for these rules, then it could be used for a lot of other rules that would be even worse. So I think the 2010 order was more of a fight about legal authority than about the substance of the rules. In 2015, I think the challenge was about equal in terms of the substance of the rules and also the authority, because the big difference from 2010 to 2015 was the rules in 2015 were based on Title II rather than Title I, so big change in authority. And also they added an additional rule in 2015 that wasn't in the 2010 order to prohibit paid prioritization, which wasn't really a popular term back in 2010, but has now become part of the dialogue around net neutrality.
So with the current rollback, what exactly is being proposed? Are we just shifting the jurisdiction from the FCC to the FTC? Is this a deregulation? Are any of these rules simply disappearing, or are they only being moved over to the FTC's jurisdiction? Randy, do you want to take that?
The current proposal, in effect, it will roll back any prohibitions against blocking and throttling, any prohibitions against slowing down applications and data. We currently have those protections. And I think of data as humans. It's, we mined gold over 100 years ago. People today mine data. It's, and net neutrality created a type of anti-discrimination law for data, a way to protect anything that can pass through legally. And so what this current proposal is doing, it's rolling back a protection that we were able to finally establish for the internet to make sure that everyone has an opportunity to make the most of the World Wide Web. It's no secret that for over 15 years, this debate has been going on how to protect lawful content flowing through the internet. And we've seen before complaints from edge providers of the internet service companies requesting for contracts, requesting for money, just to make sure that their content flows through. And that is just the beginning of a slippery slope. So for over 15 years, we have been fighting to protect data, to create laws, anti-discrimination laws of data. And we were able to succeed in 2015. It passed in the courts. We regulated the internet under Title II, which yes, it's a communication service. And to the best of my understanding, the 1934 Act is still in effect. And Title II says that communications should be given to every person, regardless of race, gender, or creed. And the way we communicate in this century is through the internet. So it's imperative that we regulate internet under Title II. That's the purpose of communications. And we were able to succeed in 2015 on finally getting these anti-discrimination laws passed. And what's happening right now is that we're rolling back those protections. Imagine any labor protections we were able to succeed in the last century. We were finally able to succeed in internet data protection. and we're rolling it back right now.
Tom, you want to respond to that?
Yeah, I mean, I guess I don't, quibble with the characterization of the Restored Internet Freedom Order as rolling back the 2015 regulations. It is explicitly doing that. I would quibble, I guess, a bit with the timeline. I mean, net neutrality didn't enter, the vocabulary until Tim Wu came out with it in 2003, 2004-ish. But I would say that actually, I guess to plug my own work, at an op-ed in Morning Consult earlier this year about the origin story of net neutrality, actually tracing it back to the computer inquiries from the 1970s and 80s, back when internet access was first a thing. It wasn't really commercially available, but it was still used in universities and I guess a few places. But at that point, we still had the nationwide monopoly of Ma Bell, which was regulated under Title II. That's what the whole framework was originally designed for, one nationwide monopolist and using regulation to protect consumers instead of competition. And we had rules back then. They allowed Ma Bell through its other subsidiaries to offer enhanced services, the precursor to information services, including internet access, but it had to do so via separate subsidiaries than the Ma Bell monopoly telephone network. And they had to, importantly, not unfairly discriminate against independent enhanced service providers. So I think that is really the precursor to modern net neutrality rules, as I argued in that op-ed. And it is all just about unfair discrimination by broadband providers in terms of either traffic management practices or interconnection practices, the pricing that they, the prices they charge to edge providers and other telecom providers to carry traffic back and forth, because they don't do that for free. They're, businesses.
So I think we're at the point, at least I guess, where both sides ostensibly are saying that, we support net neutrality, but from what I understand, at least those supporting the rollback, the current rollback proposed by the FCC, are saying that, we support net neutrality. It's just that the FCC is not the correct body or government body to regulate it. Is that a correct characterization, or is that incorrect?
I mean, people have a lot of different opinions still, and it's still only a draft order. It could change before the FCC votes on it on the 14th, or they could still pull it and push it back further if they want to make substantial changes. But in terms of what's happening, I guess they are proposing to shift primary jurisdiction over broadband to the FTC when it comes to policing any anti-competitive behavior, unfair, deceptive practices.
Can I stop you there? I'm not sure if I misheard you earlier, but is there a no throttling rule enshrined in the proposal that would just be regulated by the FTC, or is that completely out, or is it complete rollback? Because that's my misunderstanding.
No, sure. Yeah, to be clear, at least last I saw the draft order, again, it's still a draft, it could change. It proposes to get rid of the bright line rules on blocking, throttling, and paid prioritization, as well as the FCC's general conduct standard, while keeping the transparency rule and enhancing it in certain other respects, particularly with regard to any blocking, throttling, or paid prioritization, saying there's going to be specific requirements that if ISPs do engage in any of those practices, they have to disclose it in a clear and easy way for consumers to understand. But we are switching, from an approach to net neutrality based on ex-ante rules, those specific prohibitions on blocking, throttling, prioritization, to an ex-post approach that just says ISPs can't engage in any unfair methods of competition, their antitrust authority, or any unfair or deceptive acts or practices, the FTC's Consumer Protection Authority.
Are there actually definitions for those terms, though, and how do you really determine what's unfair?
Right. So now we get into the debate between rules versus standards, which is super fun for wonky Washington insiders. So industry and consumers need certainty. You need certainty to make business investments, purchasing decisions, all that. And if you start from a high-level statute, for example, the FTC statute, Section 5 of the FTC Act, forbids unfair methods of competition or unfair deceptive acts or practices. The FCC, in Title II, the core, protections there, and 201, talking about no unreasonable practices or no unreasonable discrimination. I think it was in 202 and 201 is like all practices for in connection with telecom services must be just and reasonable.
I will say, I just wanted to add, different people define discrimination in different ways, right? So how do you
Right. So
how do you reconcile that?
Right. Of course. Yeah. The rules and the laws don't prohibit discrimination, full stop. They prohibit unfair discrimination, because discrimination in and of itself is not a bad word. For example, we're talking about in the context of net neutrality. If your ISP wants to favor VoIP applications over email applications, I think that should be fine, because based on the characteristics of those services, VoIP, requires certain QoS levels that email doesn't in order to deliver a rich quality of experience for users. But, compare if you're treating VoIP differently than email, that's one thing. But if you're treating Skype differently than Google Hangouts, that's where you start running into anti-competitive discrimination. If Comcast, for example, I think someone else brought them up earlier, if they, strike a deal with Google to prioritize Hangouts in a way that isn't available to Microsoft for Skype, then that arguably, harms the marketplace. And I guess, there could be benefits to that as well. Exclusive deals are assessed under the rule of reason under the FTC Act to assess the harms to consumers and competition and the benefits to consumers and competition, and try to weigh the harms against the benefits and only bring enforcement actions when on net the practices are harmful. So in a case like that, that's the sort of unfair discrimination between edge services that we're concerned about, that net neutrality is designed to, if not prohibit entirely, at least to police and regulate to make sure that, they don't actually get out of hand.
Oh, Randy, I wanted to ask you, I know you work a lot with communities of color, and you mentioned that this possible rollback could really impact those communities. Could you talk a little bit about that?
Yeah, and it could be also in response to Tom right now, where we can talk about prioritizing Google Hangouts versus Skype and how that might harm the marketplace. What I'm seeing is, and you see all these horror stories of what could happen if net neutrality is repealed, how your internet pricing structure when you get the bill at home could be changed to make it more confusing, to make it at the end of the day more expensive for lower income communities, corporations, and a small amount of big broadband companies to avoid these anti-discrimination laws. They're smart. They understand how to game the market to make sure that they maximize their profits. That's their role, that's their job to their shareholders. So it's in their best interest to make sure that if net neutrality is repealed, we can structure the market, manipulate some billing schemes in a way that's maybe a little confusing at first, but at the end of the day, very beneficial to our bottom line. Well, the scariest potential out there is this paid prioritization idea. Even just the idea that anyone that creates an app and to just get it out there on the internet, just get it out there so anyone with a phone, anyone with a tablet or a computer can access your app. If you create a scheme where you have to pay into the marketplace just to get into everyone's home, you created a barrier. And not everyone will be able to overcome that barrier. In my community up here in the Bronx, when I was recently running for city council, and a lot of the conversations I was trying to have with constituents was how the internet moving forward can be very beneficial to your life. And yes, I'll tell you this. This is the Bronx. A lot of times people say it's one of the most lowest income communities in America. So a lot of parents would say, hey, Randy, the internet's not going to pay my rent or the electricity bill. So come at me with something more important. But the younger people would actually appreciate and get invested in this. And if I'm having conversations with young people in my community and I tell them, look, if we can implement a program where coding as a second language is an initiative here in the Bronx, in a generation, we can teach at least half of the people here how to code. And they have now the tools and the resources to succeed in this digital society that we're coming into. If we now all of a sudden take away the protections that make sure that anything they create, now that they learned how to code, will be able to travel freely through the internet, be seen by every single person in the world, that's the market potential. That's the certainty that net neutrality in 2015 created. What we're doing now is creating a certainty in the market for existing big broadband corporations. We're rolling back anything that they don't like, and we're empowering a federal agency like the FTC to enforce anti-discrimination, but they've never enforced net neutrality protection specifically. So it would be entirely new to the FTC. On top of that, it's, agencies are creatures of whoever's president. Right now, we're going to roll back net neutrality, give power to the internet to the FTC, and we have a Trump administration there. With all due respect, that's not what I told a lot of people in the Bronx was the promise of the internet. And I don't want to be a liar. So I want to make sure that keep these protections. And...
Tom is dying to respond to that.
I had a few points. I mean, it sounds like you're doing great work in the Bronx, so I fully support all of that. But there are a few things, that I wanted to push back on. I guess in reverse order, I'll try to remember them. About the FTC's experience here, I don't know if you've read the FTC's 2007 Broadband Competition Policy Report. Maureen Olhausen, the acting chair at the FTC, who spoke at our event this week, was one of the authors on that report. But it was 170 pages long, and it delved entirely into net neutrality and all the issues that could happen with net neutrality, basically about vertical restraints on trade, exclusivity agreements, prioritization, interconnection pricing. They addressed all those issues and have, I would say, all the expertise they need to handle these issues. And actually, before, I guess it was in the late 90s and early 2000s, the FTC brought multiple enforcement actions against AOL, CompuServe, several other ISPs in the early days of the commercial internet for unfair and deceptive billing practices. They didn't get into like traffic management and interconnection pricing, but they have some experience bringing enforcement actions against ISPs, as well as a bunch of other high-tech companies like Apple, Google, Facebook, Uber, the pharmaceuticals industry, microprocessors, semiconductors, a lot of complex areas. So I don't think broadband is in any way outside their expertise. So the FCC has more expertise, but I think the FTC is probably up to the task based on at least that report from 2007, which was great. Highly recommend it to anyone who's interested. But the other thing I guess I want to push back on, you rightly point out that any, board of directors at a corporation has a fiduciary duty to their shareholders to try and maximize the value of their shares. That doesn't necessarily mean short-term profits, but ultimately to maximize the value of your shares, you make profits. That's true of broadband providers. That's true of edge providers. Everyone is trying to maximize their profits and growth. That's how, these companies work. That's how competition works. I don't think it's anything, necessarily bad about it. But I guess to your point about pay prioritization and raising barriers to entry, I think that is an important point. A lot of people raise it and it makes some sense, but I feel like people, I guess, don't think about it in the full context of things in terms of how the internet works and how traffic exchange works between ISPs, because every single edge provider, every app maker, every website, that you all pay for interconnection. Whether you're paying directly or indirectly, you are paying for ISPs to carry your traffic. If you're very small and you're just running your own website, maybe on a homebrew server in your house, then you're just paying whoever your ISP is, and they will pay other ISPs and transit providers to get your information wherever it needs to go. If you're a bit bigger edge provider, then you're going to pay a transit provider like a Cogent or a Limelight or a Level 3 or an Akamai, and they will take your traffic to everywhere else. If you're a really big edge provider like a Google or a Facebook, you directly interconnect with all these tier 1 ISPs and pay them directly to carry your traffic. So, the fact that, any pay prioritization, the fact that there's paid in the word implies that there's a toll, someone has to pay a price to get that level of service. That scares a lot of people. But I think some of the people who are scared by that don't realize that there's already a price on carrying this traffic. And
I don't think it's the paid that people push back against. I don't think it's the paid part that people push back against. It's the prioritization part. It's the not treating the data equally.
Well,
at least I think so.
Yeah, I guess I hear both complaints from people. Some people are really concerned about the paid aspect, that the big edge companies are going to get prioritized service, and the ones who can't afford it then aren't going to get that same level of priority. That really comes down to the payment. Is again the framing earlier, net neutrality in its broadest concept about discrimination in both traffic management and interconnection. One being a very technical engineering thing, one being just prices, how much you're charging people for it. Some people are really concerned about interconnection pricing. Some people are more concerned about, throttling or prioritization at the network level.
So I've got a question, I guess, for Randy. With the 2015 Open Internet Order, the 3 bright line rules, whether it was the 2015 Open Internet Order or the 2010 Open Internet rules that established, I think, that most consumers support rules around throttling and no throttling, no paid prioritization, no blocking content. Why exactly would you say that the rollback is necessary? Whether or not the FTC is capable of enforcing those unfair business practices or preventing unfair business practices or not, it seems like at least now we have these rules in place. So why fix what ain't broken? Tom.
Okay, so this comes down mostly to the Title I versus Title II debate. So briefly touched upon earlier, the FCC, Title I is their lightly regulated information services. Title II is, bigger framework, more heavily regulated for telecom services. And importantly, the FTC has jurisdiction over every company and industry in America, with a few limited exceptions that are handled by sector-specific regulators. One of the exceptions in the FTC Act is common carriers. The FTC does not have authority to regulate common carriers. So when in 2015, the FCC reclassified broadband from an information service to a Title II common carrier service, the FTC lost its jurisdiction over broadband providers, which isn't as big a deal when it comes to network management and interconnection pricing, because the FCC and FTC are, both able of regulating those, I think, and arguably the FCC has more experience regulating them. But when it comes to privacy and data security, the FTC is by far the more experienced and capable regulator in terms of the number of enforcement actions they've brought, their experience regulating it throughout the internet ecosystem, not just broadband providers, but application providers, content providers, healthcare providers. There's lots of, industries where they regulate privacy. And that was a big sort of collateral effect of the 2015 order, which was one of the big reasons that we pushed back on it at the time, saying that you can do net neutrality. I mean, we at the time said you could do net neutrality rules like the 2010 order based on Title I and Section 706. You just have to structure them differently. If you guys remember the Verizon decision in 2014, they struck down the 2010 rules because the judge there, Judge Tatel, found that they were tantamount to common carriage, and you couldn't impose common carrier rules on broadband providers unless they were classified as such. So in 2014 May, the NPRM that led up to the 2015 order, if you guys recall, Chairman Wheeler actually proposed to not go down the Title II route. He said, we're going to stick with Title I, enact a commercial reasonableness test that essentially mirrors the 2010 order, but allows for more individualized negotiation when it comes to pricing. And that, I think, would have been enough to survive judicial review. And we thought the FCC could have enacted net neutrality rules without using Title II. They eventually obviously changed course later that year and said that we need the strongest authority possible, and we're going to do these strong rules. And yeah, there will be some privacy, complications, but in that case, they resolved them through a memo of understanding between the FTC and the FCC, under which the FTC agreed to advise the FCC on privacy and data security with its greater experience, but it no longer had the authority. So that's how it resolved it.
There was a bias privacy rules proposed by the FCC that were set to go into effect, right, before IGPI became chairman and rolled those back, or I guess decided not to implement them in the first place. Wasn't that correct? Or
it's, largely correct. In minor detail, there were petitions for reconsideration pending before the FCC this spring, and I'm sure that Pi, and it would have just been Pi and O'Reilly at the time, probably would have acted on those petitions for recon and undone the rules, because they dissented from the order in October of 2016. But Congress used the Congressional Review Act, the CRA, to undo the rules on their own before the FCC could actually do that. So it was Congress, not Chairman Pai, who undid the privacy regs. Although I don't know how much that matters, because I think Pai would have undone them anyway.
I think I would just like to say that, yeah, it's also no secret that corporations don't want to be regulated. Corporations and types of industries will do as much as they can to avoid federal regulation. But the Communications Act is the law of the time. It hasn't been repealed. It's been amended. And communications is defined in a certain way. And internet service, the type of service that it is, the type of access it provides, and how people use it today, that fits the definition of communications. And it's no secret that being regulated under Title II as a communications service, it's not ideal for corporations as opposed to being just an information service. It does come with a little more scrutiny, but it comes with a little more responsibility. But there's a reason for that, and there's a.
Can we dig into that? Why do you think corporations would prefer that the FTC take regulatory control over this than the FCC, Randy?
And from my experience, it just seems like the FCC, yes, they do ask, they inquire a little bit more, they ask a little more questions, their scrutiny is a little bit higher on a lot of issues. Companies would rather deal with the FTC than with the FCC, just for ease of dealing with that type of agency in this process. Even the Wheeler FCC in the 2015 order created this new framework for coming in and explaining whether or not your practice would violate these bright line rules. And yes, that's a burden on private companies that they have to establish maybe a new department, maybe hire a new attorney. But at the end of the day, these big broadband dollar corporations, they can afford to have a new department if it ensures that we maintain these anti-discrimination laws of data with this ideal of protecting an open internet.
Tom, you want to respond?
Yeah, I want to jump in a couple points. I guess first, a lot of telecom companies are multi-million, billion-dollar corporations and have teams of attorneys, very smart people who can handle regulatory compliance. But of course, the 2015 open internet rules applied across the board. There was an initial period where they didn't apply to small businesses, but that lapsed because it was just an interim period. But the rules applied across the board, and at least if you ask Chairman Pai, he has a lot of, record evidence from smaller ISPs who don't have, a bunch of attorneys on staff and maybe can't afford to hire them, at least on a permanent basis, who were being, even more hurt by the rules than the big guys. Typically, big companies can afford regulation, but I think the 2015 rules had a disproportionate impact on small and rural broadband providers in particular. But to the earlier question, about why broadband providers would prefer to be regulated by the FTC than the FCC, although it's still going to be both, I think they mostly just want for a level playing field throughout the internet ecosystem. The same standards, but no unfair, deceptive acts or practices, no unfair methods of competition, to apply, equally to Comcast as they do to Google or Facebook or Netflix or whatever. Because I think the 2015 order largely assumed that broadband providers are the ones with market power, and they're the ones who have all the leverage in these negotiations with edge providers. And sometimes that's true. If you're a tier one ISP like a Verizon and you're negotiating with some small edge provider or transit provider, you probably have greater leverage in that negotiation. You're going to get more favorable terms. But that's not the case across the board. If you're a small ISP in my home state of Kansas and you're negotiating with Netflix, I would say the bargaining leverage is in Netflix's hands there. They're probably going to get more favorable terms than the ISP because Netflix, could probably afford to, lose a bit of subscription revenue if their customers who are on a network and suddenly they can't access Netflix because there's an interconnection dispute that can't get resolved. Netflix could probably afford to take those losses from any lost subscriptions in the short term, more so than the ISP. If the ISP has all its customers who suddenly can't watch Netflix, they're going to be complaining to their ISP, and assuming they have any option to choose, which most people do, although a lot of people don't have much choice, if any, then, in that case, it's, unfair to assume that the broadband provider has all the power when they're dealing with, a Netflix or a Google. So I think under the FTC, their standards would apply, they're, consistent standards across the board, and they would apply differently in different contexts, to a big edge, a big telecom company negotiating with a small edge company. There's, likely that the FTC would, fall on the side of the small edge company and bring enforcement action against the big telecom company if they're trying to use their leverage to extort, higher prices or otherwise exert anti-competitive pressure on the small edge company. But it would also, work the opposite way in the other situation where you have a small telecom company and a big edge provider who's threatened to withhold content if they don't get more favorable terms. So I think that's the big benefit, or one of the least big benefits of switching to the FTC, is that you get a consistent, level playing field, consistent standards throughout the ecosystem that can account for the differences in market power and leverage in these different negotiations.
So I want to pivot just a little bit, and I want to ask, why do you guys think this seems to be such a partisan issue? Randy, do you want to take that?
It's maybe a culture of DC in and of itself. A lot of the broadband companies that don't want to be regulated are friendly with members of Congress that are of a certain party, and a lot of these it's usually the edge providers and activist groups that are on the other side and typically friendly with people on the other side of the party. And so if you got a lot of strength and power moving in a certain direction, you're going to see the partisan side take weight. I think we're having the really good discussion here where we're actually cutting through the issues. I completely agree with Tom on, the 2015 order might have ignored rural communities and smaller internet providers. And in the future, because we're going to have to get this right, the internet's only just got started. in the future, we should bring all of these complaints and issues to the table because these concerns matter. And that's the only way that we're going to actually move forward. Because right now, we're in that culture. It's win-loss in whatever party you're in, and you try to get the wins wherever you can. And we're not always sticking to facts. It's usually talking points, and you try to sway the argument as much as you can that way. But I think we're doing the right thing here. We're laying all the concerns out on the table, and I think us four could probably fix this issue.
Right? Yeah, with enough time.
I agree.
But,
humbly, I agree. Thank you.
I guess to follow up on that, I certainly agree that there's a fever pitch of, partisanship around net neutrality these days, and has been, I think, since the 2015 order, or the 2010 order. It's also a 3-2 vote. And the first net neutrality enforcement action brought against Comcast in the BitTorrent throttling case back in 2008, also a 3-2 vote. So the FCC, typically has done sort of nerdy inside the Beltway telecom regulation that hasn't gotten any, attention from people in the rest of America, but that's changed a lot in the last decade or so. As people, use the internet more and start to love it, they start to care more about these issues. And I guess there's a lot of contributing factors to why we're in the situation we are today. Some of them are outside our control. But in terms of the fight, it's still an ongoing, it's a trench war, and it's pretty ugly. Not even, with ad hominem, personal attacks on people, not really talking about the issues, at least in the sort of, rational way that we are here. But I think that's gonna, it's sort of intractable. It's going to continue to be that way until Congress or the courts actually intervene and solve this issue one way or the other. Because as we've seen, with the level of deference that agencies get in interpreting the law under Chevron and various other precedents, the FCC has broad leeway to regulate broadband very lightly as an information service. That was upheld by the Supreme Court 6-3 in the Brand X case back in 2005. But they also have authority to regulate under Title II. That was upheld 2-1 in the DC Circuit, denied en banc review last year. There's still Supreme Court cert petitions pending, but I don't expect those to be heard because there should be moot soon. So it's going to keep swinging back and forth from administration to administration until Congress or the courts intervene and say one way or the other, this is how you're going to regulate broadband. You can do this, you can't do that.
So before we move on then, what does a legislative net neutrality fix look like, and can both sides of the aisle actually come to an agreement?
Or a judicial fix? What would that look like?
Yeah.
Well, a judicial fix would be pretty easy to understand because I was on an amicus brief in the challenge to the U.S. Telecom case back in 2016, arguing that basically the precedents from Brown and Williamson and utility air regulatory groups saying that on major questions of economic policy, that the typical Chevron deference is inappropriate and they should have a more searching standard of review. That was not, that brief didn't, wasn't very persuasive to the judges in that case. But that's the judicial watershed, moment that we're waiting for, is for, the judiciary to strike down, I would say, administrative overreach and say that you can't make such policy. Policy needs to come from Congress first and foremost, and then agencies can, make minor changes on the margins, but not fundamental shifts back and forth. That would be, I guess, what it would look like in terms of, further reining in Chevron deference.
Or you. Mm-hmm. or alternatively, the court could uphold it. But
right. So, from my perspective, it'll be a mixed bag, probably regardless in the outcome of the next litigation, because if the order gets upheld, I'll probably be happy about that outcome, but still lament the state of administrative deference in the law. But if there's a change in heart and Judge Tatel strikes down the order and says that, no, we got to have a more searching review, I'll be happy about that change in precedent, but, probably unhappy about striking down the order. But so we'll see what happens.
Randy?
I think the legislative fix, I'm sticking with my guns. We got it right in 2015. The bright line rules, that's at least where we should start the conversation. And then was it perfect? Maybe not. And then we can tweak around the edges there. But if the bright line rules aren't a part of the fix, then I don't think the conversation will go anywhere. Those are the anti-discrimination laws of data that we created in 2015. And we can't turn our backs on that. And I think it just falls in line with the purpose of the Communications Act of 34 and the way we can define the internet today. It is a communication service, in my opinion. And we'll just see how this goes. We might need a brand new Congress, some more experienced people that have definitely more experience with the internet who would appreciate this conversation, or we'll just see how it turns out.
Yeah, I agree with you. I think there seems to be a sort of a trend nowadays to blow things up completely rather than try to, tweak what's already there. But, that's neither here nor there.
I guess I won't, I don't know of any bill in Congress that could move right now. The previous Congress, it's notable that the Republicans, when they were in control of Congress in 2015, 2014, did offer what, I guess in their minds at least was a fair compromise, saying that, okay, if you want these bright line rules, we will give you bright line rules against blocking, throttling, and pay prioritization, but we're not going to give you Title II. We're going to say, you can have these bright line rules if it's under Title I. I guess some Democratic members were interested in that, and several in Congress still express interest in seeking a legislative fix, which I commend. But they didn't take that deal at the time, and I don't think Republicans would offer the same deal today, now that they control all three facets of government. But going forward, we need some legislative fix, and I'm, at this point, very open-minded about what that might look like.
Well, thank you guys for that discussion. I know I learned a lot, and I think it's safe to say that, reasonable people can disagree. We did this little backwards today. We generally dive into personal backgrounds first, but because it's such a hot topic, we wanted to jump right into net neutrality. So just really briefly, how did you guys actually get involved in net neutrality to begin with?
I got that Google Policy Fellowship that I did was in 2013. I was a second-year law student in San Diego, and it was my first stint in DC. San Diego. And it was my first stint in DC. First experience getting that policy background, the regulatory background. And it was the first time I also realized this is what I want to do. I was in tech law. I was working for an advocacy group, and it's 2013. So a lot of things are happening behind net neutrality, but also this is the summer when Snowden leaks are happening. And it's a hot summer in DC. And so if there's any, like you all have, I'm sure had the same experience where this is what I love. This is what I want to do. And net neutrality was one of the first projects that I worked on. And I was in DC in 2015. I actually was in the cybersecurity division in 2015 at the FCC when net neutrality was passed. So I saw it from the inside at that point, and I followed the court cases. I feel like I've been connected to this for a while, and I feel like the conversation isn't ending here. We're just getting started.
Right.
Sure. So on my end, I guess I first came out to DC. I grew up in Kansas, went to undergrad at Kansas. But I first came out to DC to work on the Hill for Jerry Moran, my local congressman, now in 2 senators. And then went into law school at GW and didn't exactly know what I wanted to do. But at the end of my first year, we got the Telecom Law Journal, the FCB, Federal Communications Law Journal, sent to GW from Indiana. Seemed like a good opportunity because I like nerdy techie stuff. So I applied and got onto that journal, and then decided to cut my teeth on spectrum policy because that seemed like a wonky, interesting thing to do. And so I did that, got a job at the FCC the following summer working in their wireless bureau. And then I also, took a Google Summer Policy Fellowship. Mine was at Tech Freedom, started in 2014. Actually started the same week the NPRM in the, Open Internet proceeding back in 2014 came out. So I immediately hit the ground running, and my job was to research net neutrality. And I was involved in the rulemaking back in 2014, filed comments and replies. We filed an amicus brief in that case. This time around, from our street, we're also more involved, and I guess unsurprisingly got cited a few more times in the order this time than back in 2015. But I guess I've been in the telecom bar now for over 5 years and been dealing with net neutrality the whole time. So I guess well versed in it at this point, and the arguments are very well worn, but people are still interested to hear them, so I'm happy to chat about them.
So you guys are both really laser focused on the tech policy world. One of the real focuses of the show is sort of advice for young professionals or students or early career professionals. I've got to ask, we're trying to keep it brief here, but do you have any advice for early career professionals or young folks that are trying to get into the tech policy world?
Sure. So with hindsight, I might have studied, some hard science, engineering or computer science. I ended up majoring in psychology and political science during undergrad. So I've been at a disadvantage, I guess, trying to learn all this techie stuff just by reading tech blogs and spending time on Tech Meme and Y Combinator, Hacker News, and reading through wonky FCC releases. But eventually, if you read enough of it, you get familiar with the terms, then it becomes easier. But I guess in terms of, good advice, I guess aside from a technical understanding, that is very useful, if not necessary, to work well in this area. I think also, I didn't go to business school either, but a mind for business and how business models work, I think is very important to understand how to regulate these markets. When you think of, different actors in the internet ecosystem, they're pretty much all corporations that are profit driven and they have to somehow make money. So I guess thinking about how like online advertising works and, different, subscription models versus advertising-based models and all the different actors in the internet ecosystem, many of which have no direct consumer relationship, like, all the middle mile transit providers, the equipment makers, like AdTrans and Broadcoms. There's a lot of people out there who are all involved in this space. But just as a consumer, you only interact with a few of them. So I think it's important to try and understand what's going on, underneath the hood and how the internet actually works. And I know, I guess most of the people I know at the FCC are very well versed in the internet and how it works. But I see a lot of people, weighing in on telecom policy, and they seem, a bit misinformed or confused about how things work. Which is understandable, but I would say that, understanding the technical aspects and the business aspects of internet regulation are the best way to get your foot in the door and impress people with your knowledge about these areas and grow your career.
Randy?
I would say, and this only counts if we can protect net neutrality, right? So if I'm talking to someone, I would say dream big and just try to get as prepared as you can. The internet and this technology ecosystem that we're going into can seem daunting to a lot of people. It can seem confusing, and they should trust that there's a group of mentors out there, a group of people that want to see everyone succeed and are ready to provide the training. So if you have just the training, just a little bit of background knowledge on how the internet works, maybe a little knowledge on how to code one or two languages at an early start, the sky is literally the limit. Dream big. Try to create something. If I can get someone who grew up in a low-income community to create an app that from advertisements makes just $1 million a year, like remember how big Flappy Bird was? And so if you can just get one kid from the Bronx maybe to start an app $1 million a year, she'll hire 6 of her friends and everyone's making $80,000. We just transformed the community. Again, though, just to bring it full circle, that's only true if we protect net neutrality laws. These anti-discrimination laws are really important to me.
So now we get to my favorite question of the podcast. What are you grinding for? Tom?
So my daily grind, I guess I feel very privileged to be able to wake up in the morning and go to work on things that I'm legitimately interested in and passionate about. And it makes, I guess, earning a living much better than at least the alternatives. There's a lot of ways to put a law degree to use, but being able to work on the things that I'm personally passionate about every day and try to make for a better and more prosperous, internet environment for the tech ecosystem, I think that is, I guess, the big driving force that gets me out of bed every day to grind it out.
Nice. Randy, tell me about the grind in the Bronx.
Grind in the Bronx. I grind all the time for the people of the Bronx, specifically when I realized that 60% of people in the Bronx are on the wrong side of the digital divide, meaning we either can't afford internet access, or even if we could afford some type of it, we don't know how to use, we don't have the digital literacy to make the most of the potential of the internet. It's not just the Bronx where it's 60%. These are low-income communities throughout America, rural communities, communities of color. And I grind because the future, like Commissioner Rosenworcel has said before, the future belongs to the connected. And it would hurt me to sit on a rocking chair when I'm 70 and know that I didn't do everything I could to help connect those that needed to be connected. So I keep grinding to make sure that we can connect everyone in America, and hopefully we get to this future that I'm sure the four of us, we see it. And I think working together, we'll be able to get there.
So we've just been ending our discussions by asking our guests, what book is on your nightstand? What are you guys reading these days in tech law and policy, or just in general? What are you reading, if anything?
So my campaign for city council ended 3 weeks ago.
Okay, so can you just give us like a little, like, what was it like to run for city council?
Exhausting. It's it's New York City Council. It's I would ended the Obama administration January 20th.
Me too. And then,
that was the day.
That was a sad day.
Or a great day for some.
For some people, it was a great day.
And I went right back to my hometown community in the Bronx. Campaign was launched Valentine's Day. The primary was September 12th. So we're looking at about a little under 7 months to really just grind it out. It's at 6 a.m. to midnight. It's a traditional day. You do it all the time as the candidate. You're the campaign's biggest volunteer, essentially. Mm-hmm. You have to do it all. You have to fundraise.
You have to like people.
That sounds awful.
You really have to like people.
We are one of the most disengaged communities in America. 12% voter turnout is about right. Oof. So imagine knocking on doors and talking to the 88% who don't vote. There's a reason for that. There's a reason they feel disengaged, disenfranchised. And it was a lot of learning quickly on the job. What are the issues that matter most to your community, and how can you help them? It was exciting. There were 5 candidates in total in my district. I came in second place. The guy who won has been the incumbent for 8 years. Obviously, I ran against him because I thought he was doing a bad job. But I learned a lot about politics and campaigning and name recognition, and maybe don't run a campaign in 6 months, maybe a little more than 6 months.
But that's awesome. So I went to a talk by Amanda Littman, who was the deputy director of the Clinton email. She was, Clinton's email director. Yeah. She's the author of this book called Run for Something. And I went to a talk, Politics of Pros in DC recently. And she said that most people who run for the first time, they lose. And so you have to just keep doing it again. So, I mean, I would say just run again. I mean, that's amazing to even.
I'm looking at the data now, and it's like I'm sitting back and thinking, holy crap, what happened there these last few months? Like the Hillary book. And looking back at the data, it's like, hey, we lost by 1,000 votes, and I have in my community 2,500 people that I have their data, I have all their information. Definitely, we stay in touch for a lot of reasons, and it grows in that way. You really only need about 4,000 votes to win my district. Mind you, there's about 60,000 eligible voters, but you only need 4,000 to win. But if I can start at 2,500, that's good. It's growth. A lot of people told me to watch the Cory Booker documentary about his first run. Apparently, he lost his first run for city council too.
Yeah.
Congratulations. Yeah. Regardless,
thank you.
Very exciting.
So we definitely didn't talk about books, but no, that's you don't have time to read right now. You're still tired.
No, I was saying it's been 3 weeks. I'm exhausted, but and I haven't. My free time, I guess I was reading the new internet order, the Net Neutrality order. But is that really like fun reading?
No.
It doesn't have to be fun.
For some, I did pick up this book by Juno Diaz. This is How You Lose Her.
Nice.
I read his book Brief Wondrous Life of Oscar Wilde, which he won the Pulitzer for. But this one is actually, I think, better. So it's some fun reading that I've actually been able to get into, and I'm excited I can read a good book for once in a while.
I bet. Yeah. Are you reading anything, Tom?
So I guess I have more free time than Randy. Yeah. Although, admittedly, I spend much more of my free time gaming than I do reading. But you asked about books. I'm reading a book, I guess just one right now, but it's The Political Spectrum. It's by Tom Hazlett. It's about the history of spectrum regulation at the FCC.
Really cool.
Cool.
Recommend it?
Once I finish it, I will give you an honest recommendation. I could say now I like Tom Hazlett's work generally, so I'm guessing the book will be good, but I'll withhold judgment until I've actually read it.
All right, we'll make sure to get an update. Panal, what are you reading?
I am still reading Privacy in a Nutshell. I know I said that last time, but I'm planning to take my SIP exam soon. I just need to bite the bullet at some point, but after taking the California bar exam, even though that was several years ago at this point, I still don't want to take another exam, but I'm sure, Emery, you can feel my pain on that too.
I'm actually waiting to take SIP-E as well. I'm trying to get some GDPR skills, but my supervisor at Privacy Rights Clearinghouse said that SIP was about 1/8 as hard as the bar, so you'll be fine.
Yeah.
1/8, I can do that.
That's promising.
I finally finished Handmaid's Tale. I am returning to Orcs and Crake for some more Margaret Atwood, but on the tech policy space, I've got Carpenter v. US up in my tabs for the transcript today. That is going to be some night reading tonight. All right, so this week on the Foundry Job Board, we have internships, fellowships, and full-time positions across the country, and even an opening at the Global Public Policy Institute in Berlin. So if you're interested in doing some awesome privacy work, I definitely recommend checking out at least the Georgetown Law Center on Privacy and Technology in DC. They've got a summer internship that looks like it's a really amazing opportunity. They've done some awesome work in the past few years. You can check out that internship and more, all at the Internet Law and Policy Foundry Job Board at www.ilpfoundry.us/jobs. Tom, Randy, I want to thank you guys so much for being our guest today. This has been a lot of fun, and I think we got to, again, we brought it up earlier, but this is the kind of discussion that everyone needs to be having.
Yeah, thank you guys.
If you want to hit us up on Twitter for questions, comments, or just to generally Twitter stalk us, you can reach me, Pinal, at Woman of Fuego.
This is Emery. You can find me at Emery Roan.
This is Tom. You can find me at T Struble.
And this is Randy. You can find me at Abreu for NYC.
All right, and we belatedly want to thank Ali Sternberg, as always, who joined us in our first episode for providing the music for the intro and outro of the show. If you enjoyed the show, please rate and review us on iTunes. Spread the word to a friend. For a small podcast like ours, really, we have no marketing budget, obviously, so the only way we get spread is through your words. So thank you. And if you did, maybe hit us up on Twitter and let us know. It will mean a lot to us. Thanks for joining us.